Hello, everyone, and welcome to our latest immigration update. I am Ruth, a senior immigration associate, and today I'm joined by Monica, also an immigration solicitor.
Hello, everyone.
Today, we are talking about some important changes coming up for employers, HR team, and sponsors. There are actually two dates that we think businesses should have in their diaries: the 1st of September 2026 and the 1st of October 2026. From the 1st of September, there will be changes to how users access their sponsorship management system, including mandatory multi-factor authentication. And then from the 1st of October, there's significant changes to the right to work scheme.
And although this might sound like separate issues, they're both really about immigration compliance. So, if you're an HR professional, a business owner, or a sponsor, this is a good time to review your processes rather than waiting until these changes come into force. Let's start with September. For sponsors, multi factor authentication, or MFA, will be required for users to the sponsorship management system from the 1st September 2026. And this is one sponsors should be preparing for now. If you have people in your organization who access the sponsorship management system to manage your sponsor license, assign certificate of sponsorship, or report changes to the UKVI, those users will need to be ready for the new login requirements.
Organizations sometimes have users who have moved roles, left the businesses, or simply no longer need access. So before September, we recommend checking who your level 1 and level 2 users are, making sure their details are up to date, confirming that the appropriate people have access, and do not leave it until last minute. If you suddenly find that the person who normally manages your sponsorship system cannot access it, that could create practical problems, particularly if you need to assign a certificate of sponsorship or report something to the UKVI within a particular time frame.
So that's your first date, 1st September 2026. Sponsors should be ready for mandatory MFAs for SMS users. Now let's move on to the bigger topic for today, the changes to right to work checks, coming into force on the 1st of October 2026. Right to work checks are something that most employers and HR teams are already familiar with. But these changes are important because they don't just affect the way checks are carried out, they also expand the scope of the right to work scheme to cover a wider range of working arrangement.
And that's probably the key message for anyone listening today. If you're an employer, you shouldn't just be thinking about the people who are directly employed by you. You need to start thinking about the wider workforce and the different ways in which people provide services to your business. And for individuals, particularly those working as contractors through agencies or other flexible arrangements, it is worth understanding what these changes could mean for you. So let's start with the basic. What is a right to work check? A right to work check is the process an employer uses to establish that an individual is legally allowed to work in the UK. For an employer, carrying out the correct checks is extremely important because you can give the employer what is called a statutory excuse against a civil penalty if the individual is subsequently found not to have the right to work.
And that distinction is really important. It's not enough for an employer simply to ask someone, do you have the right to work? There is a prescribed process that needs to be followed, and the employer needs to retain evidence that the check was carried out correctly.
Exactly. And we have seen the right to work checks becoming increasingly digital over the years, particularly with the introduction of the e-visas and the share codes. But from October, we're going to see another significant development. So, Monica, let's get into the main changes, what actually is happening on the 1st of October 2026.
So the right to work scheme is being extended to cover additional working arrangements. Historically, the focus has largely been on people who are employees, but the new rules are designed to capture a broader range of arrangements, including certain workers, individual subcontractors, and other forms of labor supply.
And that reflects the way people work today. The labor market has changed significantly. Businesses increasingly use contractors, agency workers, subcontractors, and other flexible arrangements. So the government is essentially trying to make sure that the right to work framework keeps pace with that.
Exactly. And for HR teams, this means you need to look beyond your employee list. For example, imagine you run a business and you have 100 employees, but you also have contractors and subcontractors providing services to you. You shouldn't automatically assume that because those individuals aren't an employee, the right to work isn't relevant. The nature of the relationship will need to be considered. Does calling someone a contractor mean you don't need to check them?
And that is an important question. One of the things I think businesses need to be particularly careful about is simply labeling someone a contractor and assuming that takes them outside the rules.
Absolutely. The terminology used in a contract isn't necessarily the end of the story. Businesses need to understand the actual arrangement, who is providing the work, who has engaged them, whether there is an intermediary or an agency involved, and what type of contractor relationship exists.
So, our advice to employers would be to review your workforce arrangements now. Don't wait until October. Look at your employees, workers, contractors, agency workers, and subcontractors, and consider where responsibilities for the right to work check sits. Do existing employees need a new check? This is another question we likely to hear. I've already checked everyone's right to work. Do I need to do it all over again?
And the answer isn't simply yes. The introduction of new rules doesn't mean that every existing worker automatically needs a brand new check on the 1st of October. Employers need to look at the transitional arrangements and specific circumstances of the individual and the working relationship.
So don't panic and don't start checking everyone's right to work checks again without understanding the new requirement. Instead, use the time now to review your processes and make sure you understand who falls within the expanded scheme. Now, let's talk about another important part of the changes: digital checks. We've already seen a huge move towards digital immigration status. For many people, particularly those with e-visas, employers are already familiar with asking for share codes and checking someone's status online. That digital approach is going to become increasingly important. There are also developments around the digital identity verification and the ability to verify the right to work for British and Irish citizens through digital means.
Which should make the process more streamlined in some cases. But I think the important message for employers is don't assume that because a check is digital, it's automatically compliant. You still need to use the correct process and retain the appropriate evidence. Digital doesn't mean informal, you need an auditable process. There is another issue we shouldn't overlook, and that's discrimination. Employers need to comply with right to work legislation, but they also need to make sure they're not discriminating against applicants because of their nationality, ethnicity, or perceived immigration status. For example, you shouldn't have a situation where you ask some applicants for additional documents simply because you think they might not be British. The same lawful process should be applied consistently, and that's particularly important as the system becomes more digital. Employers need to understand what documents and information can legitimately request and when. The new draft Home Office Code specifically says employers should not treat applicants more or less favorably because of the type of retro check they use, including whether they use an e-visa, the Home Office online service, or a digital verification service.
So, if you're listening to this as an HR professional or business owner, what should you actually be doing right now? I suggest five things. First, review your workflows. Don't just look at employees, look at workers, subcontractors, contractors, and agency workers. Second, review your contracts and processes. Make sure you understand the nature of those relationships and who is responsible for carrying out the relevant right to work checks. Thirdly, review your systems. If you're using an external provider or digital checking service, make sure you understand how the October changes affect you.
Fourth, make sure your HR and recruitment teams are trained. And fifth, keep good records. If you're relying on the statutory excuse, you need to be able to demonstrate that the correct checks were carried out.
And for sponsors, I will add a sixth. Review your sponsorship management system users before the 1st of September and make sure that the right people have access and their details are up to date and they are prepared for the MFAs.
What about for individuals? For individuals listening, the main message: don't assume these changes only concern employers. If you're working in the UK, make sure you understand your own immigration status and any conditions attached to it. For example, some visas restrict the type of work you can do, the number of hours you can work, or whether you can be self-employed.
And if you're moving between different types of work, perhaps from employment into contracting, it's particularly important to check that your immigration permission actually allows you to do the work.
So if you're an employer, HR professional, or sponsor, there are 2 dates to remember. 1st September 2026 for the multi-factor authentication for sponsorship management system users, and 1st October 2026 for the changes to the right to work check scheme.
Exactly. And the most important thing is not to wait until this date arrive. Use the time now to review your work, your contract, your right to work processes, your record keeping, initial response, or your SMS system access.
Thank you everyone for listening to this podcast, and we'll catch you at the next one.
Thank you for listening.